Morning, colleagues. The Committee of the Whole will reconvene at 10:34 a.m. Prior to bringing in the panel as motioned by the body, we'll just go ahead and flesh out the rules of engagement for our Committee of the Whole. The rules of engagement shall be as follows. We'll begin first by an opening statement by the author and afford the author his opportunity to pose his questions to the panel. We will then go into a round one where any member may pose questions to the panel. After round one, we'll go into a round two where we will allow members to once again pose questions to the panel. After round two, unless there's a motion by the body to proceed for a round three, we'll go ahead with the closing by the author and any additional questions he may have. After that time, we will dismiss the panel, and at that time, amendments will be entertained for the bill. So we will not be making amendments over the course of the discussion with panel members. This is to avoid panel members getting involved in amendment discussions that should be limited strictly to members. After amendments have been entertained and exhausted, we will entertain a motion to rise with any recommendations. Do any of my colleagues have any questions or comments with respect to these rules of engagement? Madam Vice Speaker.
I appreciate the rules.
Acting Speaker, I'm sorry.
I appreciate the rules, and I just wanted to ask if we could, after you dismiss the panel and you're entertaining amendments by the members, if you could also entertain just remarks. I mean, our normal course of debate and amendments, not just amendments. Yes.
After we dismiss the panel, we'll entertain amendments, and if any members wish to further have any discussions on the bill, we'll definitely entertain those as well.
All right. Thank you very much.
Any other members wish to clarify our rules of engagement for today's Committee of the Whole? If none, Senator Espadon.
Thank you, Mr. Chairman. I appreciate the rules also. However, if amendments are being proffered after we have excused the panel, and there might be some information that we may really want to have clarified by members who have been excused, bottom line is we might miss that opportunity. Do you plan to ask them to stay in case we need to bring them back in to answer any questions relative to any amendments that are being made?
What I would recommend is we exhaust as many questions as we can during our rounds of questioning. I want to avoid members of the panel debating with members of the body. If members of the body wish to get clarification from a panel member after we have dismissed them, we can go ahead and entertain a brief recess where the members can confer with that panel member. If the members believe that the panel member's statements are necessary for the record, we can entertain a motion to put the panel member's statements on the record for the body to consider. But in previous experiences of committee as a whole, we've oftentimes gotten into these lengthy back and forths with panel members that not necessarily resulted in greater clarity. And so I would like to avoid that on the amendment process so that it's strictly just members' discussion. And if members want to get more clarity from a panel member, we can, we can recess and you can get that discussion offline. Is that satisfactory?
Yes, I suppose so. So I guess just to clarify, you will ask the panel members to stay here in the legislature, maybe not specifically in this room, but for any questions that might be needed to be asked them. And I raise that as an issue of concern because who knows what the amendments are going to be and whether the relevant questions were really asked or answered to be able to fully address and vote intelligently on any amendments that are going to be proffered. So I ask that, and I appreciate I ask that you do recommend to the panel, once they're excused, to stay in the building so that if we do have questions relative to any amendments that we might be able to confer with them.
Absolutely, we'll do that, Senator Espadon.
Thank you.
You're welcome. Any other concerns by any members of the body? If none, I'd like to ask the Sergeant at Arms to please bring the panel members in for our Committee of the Whole. Thank you, Tom. We swore the members of the panel in because we are going to be discussing a potential government claim and the veracity of that claim with respect to potential appropriations that this body might need to make to fund that claim. And so we wanted to make sure that, for the record, all members of the panel were sworn in. At this time, I'd like to take a brief opportunity to allow the members of the panel to introduce themselves, starting from my far left. Mr. Horeki, just a brief introduction.
Thank you, Mr. Chairman. Senators, my name is Frederick Horeki. I am the attorney for Koku Recycling, who would be the recipient of this bill.
Good morning. My name is Walter S. Leongaro. I'm the Administrator of Guam EPA.
Good morning, Senators. Carl Espaldon, Deputy Attorney General for the Solicitor Division of the Office of the Attorney General.
Good morning, Senators. I'm Ken Orcutt. I am the Deputy of the Litigation Division at the Office of the Attorney General of Guam.
Good morning. I'm Michael Borja, the Director of the Department of Land Management and the Chamorro Land Trust Commission.
Thank you, gentlemen, for joining us this morning. We resolved in the Committee of the Whole to discuss Bill number 350-34, introduced by Senator Rodriguez as the main sponsor. As per our rules of engagement, he will be making an opening statement and he'll be posing questions. I did want to notify the panel of some rules of engagement for panel members. Members shall speak when recognized. They shall answer questions to the member's satisfaction, and they shall not debate members with respect to the lines of questioning. Now that that's clear, Senator Rodriguez, the chair will yield to you for your opening statement and any questions you may have for any members of the panel.
Afade, thank you very much, Mr. Chairman. I want to thank the panel for being here this morning as well. Mr. Chairman, before I start my opening, I'd like to request the body that if a representative from the Mayor's Council does come this morning, they'd be allowed to join the panel this morning. I believe their input in this is important as well.
Without objection, so ordered.
Thank you. Mr. Chairman, Bill 350 is an act to provide an annual continuing appropriation from the Recycling Revolving Fund to provide payment for prior year obligation resulting from a 2001 license agreement executed by the Chamorro Land Trust Commission for 25,000 metric tons of metallic and other waste removal from the island of Guam, and also approving and authorizing the CLTC to make amendments to the 2001 license agreement. Mr. Chairman, what this bill really stems from is a license agreement in 2001 that established an ongoing legally binding contract between the Chamorro Land Trust Commission and Koku Recycling for removal of metallic waste and old tires from Guam. The Chamorro Land Trust Commission stated in the license agreement that the amount of waste removed had been determined and agreed to be in excess of 25,000 metric tons. The Chamorro Land Trust recognized in March 2006 that based upon a recent inspection of lot 10122-15 in Dededo, better known as the Dededo Metallic Waste Station, it appears that the property has been substantially cleared of metallic waste, end quote. Moreover, Mr. Belly Bello, the president of Koku Recycling, and his representative, Attorney Fred Horeki, who's with us this morning, have presented shipping receipts to the legislature indicating that Koku Recycling has removed approximately 50,000 metric tons of junk cars, other metallic waste, and old tires from the Chamorro Land Trust property and shipped them off island. Mr. Bello did not agree to only be compensated for the 25,000 metric tons of metallic waste removal. This Governor of Guam liability could have been upwards of $15 million. The Chamorro Land Trust is able to absorb 1.599.488 million of this debt in the form of credit in lieu of cash payment from the licensee, since that amount is what is projected that the licensee will pay in total lease payments over the course of this amended agreement. Given that it would be difficult, if not impractical, for the Chamorro Land Trust Commission to issue rental credit as compensation to licensee to satisfy the remaining 5.9 million liability, the Recycling Revolving Fund has been identified as an available and viable source to provide for the remaining balance. Such payments would have to be spread out over a 10-year period, since the Recycling Revolving Fund currently generates 2.9 million annually. The Environmental Protection Agency confirms that $598,512 for the first year and $590,000 for the 9 consecutive years thereafter can be allocated for a total 10-year period to meet the remaining 5.9, and such allocation of funds is in concert with the Recycling Revolving Funds mandate. And I want to also direct our colleagues to the fiscal note that was provided by BBMR that indicated that using this funding source will not impede the operations of the Recycling Revolving Fund, and hopefully we can get those statements as well from EPA this morning. Mr. Chairman, legislative precedent was set in fiscal year 2009, wherein the Recycling Revolving Fund was used to pay all prior year obligations. The work at that time involved an island-wide collection and off-island disposal of abandoned vehicles, white goods, tires, and batteries. And so, Mr. Chairman, just to back us up a little bit here, in early 2017, we were approached by both the representative for COCU, Attorney Fred Harecki, and as well as Department of Land Management, the Chamorro Land Trust Executive Director, Mr. Mike Borja, as to the need for legislative action to be able to allow the government to resolve this 17-year legal obligation. I know that they have also approached the chairman of LAN at that time, Senator Tom Atta, so I know he was aware of this as well. What was requested of the legislature at that time was that legislative authorization to allow the Chamorro Land Trust Commission to amend existing license agreement, and for us to be able to identify a funding source, because the Chamorro Land Trust Commission was not able to absorb the entire obligation. And at that time, I definitely agree that it should not just be borne by the Chamorro Land Trust, as the work that was done by COCU Recycling really benefited the island of Guam. And so the appropriate source of funding that we've identified was the Recycling Revolving Fund. We've talked and worked with the Environmental Protection Agency administration, with the Mayor's Council, and all seem to be on the same page that this is the best course of action for us to be able to, number one, resolve the 17-year-old obligation that the government needs to resolve, and the funding source would be the appropriate funding source to use. And so that's where we're at today. We've introduced Bill 98, that was in March of 2017. There was some work that needed to be done on the bill in coordination with the chairman of the committee that had jurisdiction in working with the parties involved. And so we then reintroduced the similar measure, Bill 228, that was in January of 2018. Again, in an effort to be open and transparent, to ensure that this effort is resolved in this term, we did more work. And so that resulted in the reintroduction of a similar measure, which we have before us now, which is Bill 350-34. After the public hearing, when we did hear the concerns of the Attorney General, we did also, we as the sponsor did our best to accommodate the concerns of the Attorney General, and so we had worked with the committee, and so the committee had substituted the legislation. That's what we have before us, the substituted version of Bill 350-34. And so that's where we're at here in a nutshell, Mr. Chairman. And I welcome our colleagues, their input and their concerns and any questions that they have, because this bill has been here in this body now, at least in this term, for about 2 years. And there was an effort to be open and transparent and ensure that we could resolve this issue. And so I'm very happy that we're able to have a committee of the whole here this morning, and we have all the stakeholders here with us to be able to answer any questions that we may have. And so as per your rules of engagement, I do have one question perhaps for the Attorney General, and if anyone else can answer this, perhaps Attorney Harecki as well. Mr. Espaldon, one of the concerns that have been brought up to my attention, to the body's attention, is that the receipts that were provided to the legislature and as part of the committee report, these are receipts that total about I think it's about 7 million. Is that correct? About 7 million, the receipts that we have on the committee report. The issue that was brought up was that some of these receipts do not have Koku Recycling as the sole entity that is providing these receipts. They can be a subsidiary or a entity of Koku Recycling. And the question is, if these other entities, if we pass this legislation, would they have a claim now to come back and say, hey, you've passed this measure, government resolved this with Koku Recycling, but we are a party to this, to that company. Do we have a claim now?
Who will be replying on behalf of the Attorney General's office to the question from Senator Rodriguez? Carl, you're recognized.
Thank you, Senator. If I understand the question, you're already starting to ask about whether or not the government would be liable for, to other parties that may be on receipts or not receipts. Now, I apologize, Senator, but I don't think we're in a position to answer that question. First of all, we don't have any information, or we've not seen anything, and we're not really even examining that question. So from our point of view, to say whether or not, the question of, whether or not the government will be liable to certain parties or other certain parties, we are unable to answer that.
Okay, I appreciate that. Thank you very much. Perhaps I can ask Attorney Jarecki. Attorney Jarecki, this piece of legislation addresses the current lease agreement, the license agreement with Koku Recycling, represented by Mr. Benny Bello. And some of the receipts that were provided indicate that there may be other company entities that may be a subsidiary or some sort of relation with Koku Recycling. Can you explain that to the body?
Yes, thank you, Senator, and senators present. No other company would have any claim against the government for this recycling work that was done. And to establish that, first you need to go back to the license agreement itself. That is the basis for Koku's claim. In the license agreement in July 2001, the CLTC indicated that the amount of the liability was $7.5 million. And that was based on a calculation of the 25,000 metric tons of solid waste that was removed. They came up with a table for determining the number of cubic yards, and per cubic yard the price was $20 for removal. So that's how the original price of $7.5 million came up. But the point is, no other company has a license agreement. That is the basis for the finding of why the government has a liability here at all. So the other companies are strangers to that license agreement. They have no independent basis or way to bring a claim against the government. Now, I would say the other companies were affiliated companies with Koku Recycling. In fact, Koku was a part of those companies. Those companies got paid through the price of the waste that was provided for the ships. So they were paid. They have no other claim. Koku was the entity that was coordinating the whole effort and actually responsible from the government's point of view. So in my opinion, only Koku Recycling has this claim. No other company mentioned in the shipping receipts has a claim. And finally, with the shipping receipts, remember, that is the excess amount that Koku is claiming. The $7.5 million was established in the 2001 license agreement. The additional amounts, which were actually 19,000 tons, were all done after 2003. And Mr. Bello and Koku are not claiming for those amounts. They're accepting the amount that was indicated in the license agreement. So those extra shipping amounts, which we believe actually the excess would amount to another 25,000 that Koku removed, are not really included in the amount that Koku is claiming.
Great. Thank you very much for that answer. Mr. Chairman, I want to direct my next question to the Chamorro Land Trust Commission. Mr. Borja, thank you very much for being here. Mr. Borja, if you can perhaps provide the body the history from your perspective on how this all began and how the Chamorro Land Trust needed legislative action in order for you to move forward with the resolution of this measure.
The original intent of the license agreement with Koku Recycling was to clear an area of land that had numerous amount of metallic debris. And so the process was ongoing. During that process, then a typhoon or several typhoons had damaged a number of areas in Guam, resulting in a larger amount of debris to be taken then to this site to be processed, well in excess of what was originally determined to be what was needed. The license agreement allows for the licensor, which is the Chamorro Land Trust Commission, to provide rental credit only for the amount that was due in rent in lieu of services to be performed in clearing out the metallic debris waste. So for the duration of that license agreement, times whatever amount that was determined, came out to the amount that's approximately just under $1.6 million. However, because of all the other clearing that had been done, the amount was well in excess of that. And the Chamorro Land Trust Commission was not willing and could not provide any other kind of agreements, an addendum to the agreement to try and compensate for this, nor was it, it was well outside, especially for clearing of metallic waste that was not already there in the first place. So that's where we came to this point where if there was some kind of appropriation for additional monies that needed to be done, it had to come, we couldn't come up with that money. We couldn't appropriate money. That has to come only from this body. And that's why we had asked that there be some kind of legislation to compensate for the remainder of what was due for the services that were rendered.
Okay, thank you for that. So that's one part of the legislation, which was to identify the proper source to compensate for the remaining. However, the contention we had during the public hearing as well was that the legislature has no authority or should not even be entertaining the license agreement or the amendment. But really, it came from the Chamorro Land Trust that came to us and said we needed that legislative authority to be able to do it.
Right, for the purpose of coming up with other amounts of money. It wasn't within the current license agreement to allow for other kinds of monies or to even provide credit beyond what was originally permitted in the original license agreement. One of the issues we had as well during the talks is that if it was going to be a credit, it could not be assignable to other CLTC license or lease agreements, commercial license or lease agreements, because then it would just basically end any kind of income flow that the land trust was dependent upon.
Thank you very much, Mr. Borja. Mr. Leon Guerrero from EPA, thank you very much for being here as well. I think your agency is critical in this because we're identifying a portion of the recycling revolving fund to be used to pay prior year obligations. And as I read in my opening, there was precedent set already in this in the past. And so I want to be able to ask your input on this measure and how you see it, in moving forward.
Thank you, Senator. As far as the precedent set in the past, I know that when this fund was moved over from Guam Solid Waste Authority to Guam EPA, there was an arrears for metallic debris that was paid out of it, and that was one of the first things that Guam EPA does. As far as the specifics, I don't know, and I can't even say exactly who was the administrator at the time. Now, in regard to this bill and how Guam EPA, or myself looks at this point. So this is a bill that is requesting expenditure out of a fund that has statutes behind it that develop this fund. And those statutes have very definitive things that need to follow, which is Guam EPA building up a zero waste program, which includes using also additional money for public outreach, as well as hiring a position to oversee the recycling situation on Guam. And that is being implemented as we speak in Guam EPA. The other portion of the statute requires the Guam EPA come up with the rules and regulations for that fund and how best to spend the money, the rest of the money outside of those mandated items within the statutes. I know it's been quite some time. We actually have the draft rules and regs that we have come to write internally within Guam EPA. We've come to an agreement with our legal counsel on the verbiage. We're about ready to do the announcement and do the 45-day period. Now, with that being said, none of those draft rules and regs incorporate this stipulation in it. We did not focus in that. We focused on, again, overall moving forward with what needs to be done for the recycling universe for Guam, for Guam. At this point, that is where we stand. The other things as far as paying arrears, using this fund, this money comes from a vehicle registration. Most of the other funds that we deal with are federal funds or program income funds, which we directly have a tie to where that money's spent. So this money coming from the registration, vehicle registration, it is not, I don't feel it's my place to say how we pay arrears. I do believe that government needs to pay its arrears, but how it transpires, and I think that's, again, with this money that's available, that's the body's determination. You tell me that that's how we're going to do it, then that's by law what I have to follow. Again, what we've done internally is to address what we feel needs to be done moving forward. If you ask us to look back, that's not my job, and I will leave it at that. I will adhere and follow any mandates that you guys have. It says that we do have the say-so and the, I believe you said 600,000, roughly 600,000. And yeah, the money is available if the body determines that this is where the money goes. That I can't say that it's not, because the money that is currently being utilized, again, by statute, leaves a lot of the $3 million that comes in annually. So that's where I was stood up on. Thank you.
Great, thank you very much. Your deputy, I believe at the public hearing, we did ask the question whether he believed, whether it be the position of EPA, that the statutes behind, as you said, the Recycling Revolving Fund, the spirit of the law, and what we are proposing that it be used now, whether it is an appropriate use of the fund. And I know what you're saying. You want to look at moving forward. For me here, perhaps for others here, it's important for us to be able to look at what we've done in the past and ensuring that we take care of our obligations, because that's one I'm going to ask the Mayor's Council later. The type of reputation that is being put out there because of our our failure to live up to our obligations. But just from EPA standpoint, does the spirit of the law conform with what we're attempting to use this fund for in paying off our prior year obligations?
Tough question. I'll try to answer. First off, I want to make the disclaimer. I'm not an attorney, so actually asking me what is legal, what is law, I understand.
I just want your professional,
my professional
opinion.
So because it addresses metallic waste disposal, it does meet that portion where it is for the recyclables, metallic waste, bottles, anything that's recyclable. So I think in the spirit, it does meet that definition of paying. But again, I don't think in the statutes it says about arrears, and that's again where it falls upon the body to determine that. But yes, it does meet what the intent is to pay or to get rid of recyclable goods in a recyclable measure. Okay. Yes, that's correct.
Okay, and thank you very much, and I appreciate that. And my question was not meant to put you in the corner or anything. I really wanted your professional opinion because you're right, and that's why this is here now. It's for the policymakers here to make that determination whether we're going to live up to our prior year obligations. I mean, as a private individual as well too, I'd like to think whatever credit cards I've racked up in the past before I got married, I wish that goes away, but it doesn't go away. To move forward, you got to look at, to be able to take care of those. That's what we're trying to attempt to do here, is to do that, to provide justice to Mr. Bello. And so I'm hoping we can move forward. But thank you very much for that. Mr. Sablan, thank you very much for being here this morning. I want to thank the Mayor's Council as well for their support on this. And the resolution that was passed by the Mayor's Council is part of the record on the committee report. From the Mayor's Council, from what I understood, talking to some mayors, is that this prior year obligation that we have for over 17 years now is becoming to be a problem for what you're doing today and what you want to do moving forward. And perhaps if you can explain some of that.
Well, good morning, and thank you for having me here. The amount of money we actually get from...
Angel, could you just real quick state your name and your title, because we didn't get you on the record in the beginning.
Angel Sablan, the Executive Director of the Mayor's Council of Guam. All the money that we spend for working on a recycling program on Guam actually comes from the Guam Environmental Protection Agency, and that's coming from the Abandoned Vehicle Fund, of which they administer. We have been using the EPA funding, not necessarily through an appropriation from the legislature. In 2015, we had a transfer actually from the governor's office from EPA to the Mayor's Council in the amount of $2.4 million. We expended all of that money except for about $500,000, which was returned to EPA. In 2016 and 2017, we did not receive any EPA recycling money, but in the FY18, the legislature did appropriate $2.1 million from EPA directly to the Mayor's Council of Guam to use for recycling efforts. We've noticed that there are not too many companies that want to get into the recycling business. And I think simply stated it's because of what has happened with cocoa. We had once upon a time a company that was contracted by the government of Guam through GSA to collect from the entire island, village by village, recyclables, abandoned vehicles, white goods, metals, batteries, tires, you name it, whatever is recyclable. What happened there was we were spending millions of dollars and from the contractor, and we weren't actually getting anywhere because of 19 villages. GSA asked us to raffle out village by village who's going to come first, next, third, fourth. Well, the village of Santa Rita happened to be the lucky one and became first. We thought it would be just a 2-week effort. It turned out to be 2 months, and at 2 months it still wasn't finished in the village of Santa Rita. And Jigo, who was the 19th village, was complaining because they're probably saying, well, by the time Mayor Lizama finishes his term, he'll be out of his term, and we wouldn't have reached Jigo yet with the recycling. So what we've done, in agreement with EPA, because we had to come up with an operations plan, which was signed by the AG, signed by the governor, we had a simultaneous effort in every village going for abandoned vehicles, for white goods, for electronics. We didn't do batteries and we didn't do loose metals because our residents can get paid for that if they bring it into the recycling companies. We didn't want to have the government be charged for something that these recyclables will pay for if the residents brought it in. Once upon a time, the recycling companies would pay for the vehicles that were brought in. In fact, when the metal price was high, they were paying $85, $100 for every car that was brought in. But what has happened was the metal price is now low, so nobody wants it. It's being stockpiled until the prices go up. But going back to your question about how is it affecting the collection of recyclables, although we've made some strides in really having our residents be aware of recycling and trying to, we still see a lot of abandoned vehicles out on the streets. We still see a lot of white goods. And even though we want companies to come forward and help us, we'll give them the purchase order. First off, though, they have to be permitted by EPA, and that number of companies is very minimal. 3 or 4 out of the many licensees that have for collecting this stuff, only 3 or 4 or 5 are permitted by EPA because they're the only ones that want to go through these licensing processes with EPA. So we're, again, handicapped by that. But the other thing is, when do they get their money? Although it's in the recycling funds, we all know that it's controlled by the Department of Administration as to when they're, luckily for us this year, with the amount of money that we've gotten from EPA and the purchase orders that we've put out, our vendors are actually getting their money. Even if it's not the total amount, but they're getting something, at least every month they're getting a payment. But I'm sure that if we took care of the past of what has happened with this recycling company, that probably more companies will be wanting to go to EPA and go through this process of getting permitted so that they can collect, so that they can dispose of recyclables. 3 or 4 companies cannot handle the amount of waste that we have on island as far as recycling is concerned.
Great. Thank you very much, Mr. Sablan. Thank you. Mr. Chairman, that's all the questions I have for now, until such time when our colleagues have the opportunity. Thank you.
Thank you, Senator Rodriguez. We will now open the floor for any other members who have any questions for this panel on this initial round. We'll recognize you in the order that you chronologically wish to be recognized. Are there any other questions for this panel by any members of the body? Senator Espadon, you're recognized.
Thank you, Mr. Chairman. Interesting. Actually, perhaps I'll ask Mr. Harecki first. Mr. Harecki, one of the statements that was made by the author of this bill was that receipts were turned in, and they totaled the amount of about $7 million. Is that so far so good?
Yes.
Okay. And then, and please, here's where I need to get some clarification. Some of the receipts did not identify Koku Recycling as on the receipts. Is correct?
Yes.
And so this question is basically, if there's $7 million of receipts, which we should rely upon to reimburse Koku Recycling for their efforts, but these receipts are not necessarily from efforts from Koku, then why should we consider those receipts as part of the $7 million that's owed?
Thank you, Senator, for that question. As I earlier indicated, even aside from the receipts, the receipts were from recyclables that were picked up from about 2003 and after. But the license agreement itself, if you read it, that was signed in July of 2001. even before that subsequent work with the receipts was done. The license agreement indicates that as of 2001, already 25,000 metric tons of solid waste and green waste had been removed by cocoa recycling at a value of $7.5 million. So the point is, you don't even really need to get to the receipts to validate the claim, because the claim is validated on the face of the license agreement. But we had been asked by Senator Atta to provide receipts of work that was done. And it was quite difficult, but we came up with those receipts that totaled about 19,000 additional metric tons that had been removed from perhaps 2003 to 2006. Now, we indicate that to show that basically COCU is compromising its claim for half the amount that it indicates that it did. But those subsequent receipts, here is the point on those. The ones that aren't in the name of COCU are in the name of BKA COCU, and I believe another entity with COCU. COCU was a part of those entities, but it was COCU's role in this engagement to centralize all the waste at the Dededo transfer site, and it was responsible for getting the waste to the ship so that it could be hauled off. The other entities were paid, as I had earlier mentioned, through the value of the metal by the shippers. But it was solely COCU that was responsible for getting that to the ships, and as I indicated, it was the sole person or entity on the license agreement. So I think those subsequent receipts are not really even critical to COCU's claim, but they just show that COCU did a lot more than it's being asked for compensation.
All right, thank you. I guess, really top of my head, if there was a claim by COCU against the government, why did this not go through the Government Claims Act or through some other avenue to try to recover what the government potentially, or what the government supposedly owed?
Yes. The reason, I think I've indicated in prior testimony before public hearings on these related bills, we have been working with the Chamorro Land Trust Commission, probably, at least myself, I've been involved since 2007, 2008. Of course, Mr. Bello was involved long before that. We have met with every director of the CLTC. Ron Tehan initially, Joe Borja, Monty Mofness, and at every turn, we were always told that this was a legitimate amount that we were seeking, that there needed to be amendments to the license agreement, but we never had the slightest hint or inclination from any government official that they were disputing the validity of the license agreement, that they disputed the amount of the claim that COCU made. So there was really nothing to show that the license agreement was being violated or in any way interfered with. And then when Director Borja became the director of the CLTC, we had met with him. He again recognized that the liability that COCU was seeking was legitimate, but he recommended, so that the CLTC could effect a solution, that we go to the legislature for legislation. So the idea was never my idea or Mr. Bello's idea for COCU to go that route, but it was the CLTC director, Mr. Borja, that had recommended so that a settlement could be authorized to go through the legislature. So again, we had another director of CLTC admitting the liability, admitting the claim was there, and in those kind of circumstances, I frankly see it as difficult to make a claim against the government when you've never had anyone disputing the amounts or disputing the validity of the compensation that we're seeking.
That's interesting.
Mr. Hereke, I think the question was, why wasn't an official claim filed? Was that question answered to your satisfaction, Senator Espadon?
In a roundabout way, yes, but no. But I'll take that because I understand if at a certain point in time there was a claim, and I'm just going to explain my position, at least a partial position on this one, is that if it was going nowhere, even though there were promises made and an acknowledgement made that there was a debt that was owed, but that debt was never paid, it would seem to me that the right recourse would be to file the claim. But, and that's just my personal opinion. And of course, I'm sure, you know, Mr. Hereke gave some good legal counsel to Mr. Bello on this one. And so, well, I guess at this point, I can just leave it at that, and although I might explore it further. But I do have another question, and Mr. Leon Guerrero, EPA, I heard what you testified to earlier. On the straight and narrow, though, $500,000, let's call it $600,000. That's basically about 25% of the annual budget that is appropriated from the legislature. And this bill proposes to take that amount for the next 10 years from the budget or actually from the revolving recycling fund, which really actually goes to EPA for its recycling efforts. How will that affect what you're planning, what the agency is planning going forward, knowing now that really you're going to be shorted about 25% of what your annual budget is?
Thank you, Senator. So again, based on the statutes, there's already about 500,000 roughly that's already being implemented as required by law, which is what we're doing, which is the zero waste and outreach, as well as the position that is required. So to take another 600,000, as you quote, about roughly 25%. So what we did in our short answer, it would be impactful for the plans because, I mean, taking a quarter out, that's taking a quarter out. So, yes.
And I take it that really a lot of those funds are really what is then allocated to the Mayor's Council to help in the recycling efforts of the island.
So if you were to take out that quarter for the next 10 years, most definitely you could not. So, and try to give you a better picture. So we spend about 600,000 based on statutes for this fund. The 2.2, again, like I had stated earlier, if the body decides to give it, that's what has happened with the 500, excuse me, let me start over. So with the 500,000 that's being proposed, much like what the body has approved in the past, that's the 2.2 million we have given, or the 2.4 million we've given to the mayor's office. Again, this is by decision by the legislative body, and so we adhere to it and we give it. That is part of the statement that I was releasing earlier. Again, if you tell us this is how we have to spend it, then we have to spend it this way. We do have our draft rules and regs, like I mentioned. It was not incorporated in our draft rules and regs. We are about ready to release the public announcement so we can start the public comment period. And that's where we are at. Again, this was not part of our initial draft rules and regs.
Okay, thank you. The issue of the precedence that was set by a previous action in which money was allowed to be spent from, I guess, the appropriation to EPA. So far, is that right? Was it money that was appropriate to EPA, and then that money was then allowed to pay off any debt?
Okay. I'm not sure about the intricacies of what happened. I do know that the way the statute was written, or is written for this fund is that there are certain mandates that must be met, and then the last mandate is come up with the draft rules and regs on how to spend the rest of the money.
Okay.
Okay, so we are almost there. What I understood had happened is that when it was transferred to Guam EPA, one of the first things that we had to do excuse me, was pay off a bill to another company that had a similar situation at that point.
And well, I guess the point that I'm trying to get to was that, and if you do know, I would appreciate it, was that payment extended over a period of time, much like this bill is proposing? This bill is proposing to pay something out of the recycling fund over a 10-year period. The precedence I'm trying to understand that was set, was that a one-time payment out of the fund, or was it also extended over time?
I am not exactly sure on that, Senator. I apologize. I can find out exactly. I would venture to say, but I wouldn't say this is the record until I check what our records are. But I think it was probably a one-time payment, but I'm not too sure at this point. I would request that I would check into our accounting records and see how that was done.
I would appreciate that, yes. Because when we speak of precedents, yes, in terms of the payment being made for a back bill, that's one angle. However, the other precedents that perhaps it was not set at that time was that the payment would come from the recycling fund over a period of time on a yearly basis. And I think that's a significant difference between what has happened in the past and what we're proposing to do here, and that needs some consideration. Mr. Chairman, I have a few more questions, but I'm going to allow my colleagues to go ahead and ask, and I'll come around in the second round and ask the further questions.
So just to clarify, this will exhaust your first round and you will yield for your second round?
Yes.
Thank you, Senator Espadon. Any other members have any other questions for this panel on this initial round? Senator Lee, you're recognized.
Mrs. Masi, Mr. Chair, and thank you very much, gentlemen, for joining us this morning in the Committee of the Whole. I have two questions, and I guess one of them is similar to a question asked previously by a colleague, but for the Director of Guam EPA, this appropriation is now for FY 2020. And I guess my question is, what programs currently funded by the Guam EPA would have to potentially be set aside to meet this appropriation from the Recycling Revolving Fund? Okay,
so in developing the draft rules and regs on how to spend the money that's outside of the statutes, what we did was come up with a scenario of multiple options that the administrator of Guam EPA has to spend the money. Again, what the thought process behind that was, let's look at a slew of options that can best be determined at that year, that fiscal year, on how to spend the money as assigned by the administrator. So we have options that exceed what the annual funding is, because it's not. If you were to implement all the options, they would exceed the annual funding that comes in. So the idea is not to meet or execute all those options, but rather give the administrator what is needed the most priority for that fiscal year. So to actually identify a certain project that would be detrimental, I couldn't do that now. It would be based on the draft rules and regs passing, and then at the time if this money is taken out, then that will limit the amount of options that the administrator has every fiscal year that this is under. Yes.
Okay, so a follow-up question. But you would have to agree that there would be some programs or some priorities that would have to be set aside if we fund this appropriation.
Of course, if there's money removed from the fund, then your options are limited to whatever is left over, correct?
So it just limit your options?
Yes.
Okay,
correct.
so Masi. And then, Mr. Chair, I just have one more question for the Attorney General representatives. There was raised, I believe, at the public hearing, a concern about separation of powers. And it's my understanding that with this substitute bill, we now have, I think it's on page 3, line 6, so section 2, attempts to address that concern by the new language reads authorization and recommendation for an amendment to existing CLTC license agreement. And so my question to you is, do you believe that the bill, the substitute bill, now having an authorization and recommendation language, in your opinion, does this address the separation of powers concern?
Senator, thank you for that question, because it is, I know, flows from our previous testimony back in November when we raised what we said was a serious concern about an egregious violation of the separation of powers doctrine. And we appreciate the legislature and the committee's attempt to address the issue, whereas before the previous iteration of the bill said that the CLTC shall execute in total, and then it laid out the actual amendment of the license agreement that it wanted to see. And we basically said that was an egregious violation. You cannot do that. That would be inorganic. But we do have concerns, and I know that they tried to, the committee has tried to address it by saying, well, it's not a mandate anymore, it's an authorization and a recommendation. So it's not a requirement here in this case. But I also want to point out the language there. It says, authorizes and recommends that the CLTC make the following amendments. And so that authorization and recommendation, again, is for very specific language which follows in the bill. Now, to further explain our position why we believe that this bill and this iteration does not cure the defect, is I go back to the 2002 Guam Supreme Court opinion that we brought up in our previous testimony, which was in re request of Gutierrez. And in re request of Gutierrez basically informed our opinion, basically saying that that was a violation because the legislature in that previous iteration was mandating not the authorization, mandating the approval of a very specific amendment to the license agreement with the language. But that Supreme Court decision relied on a decision from Arkansas, and that decision was Chafin versus, Arkansas Game and Fish Commission. And there was a constitutional challenge to a appropriations provision which prohibited the commission from entering into certain kinds of contracts without first getting the advice of the legislature. And in those cases, the contracts had to be submitted to the legislature for advice. And the process was that the legislature, a committee of the legislature would basically say, not approved and disapproved, but favorable or unfavorable. Okay? And so, and their favorable and unfavorable determination was not binding on the agency. However, the court in Chafin found that, quote, the advice offered by the legislative committee to an agency is tantamount to a legislative order on how to execute a contract. And in that case, the court found that that provision was violative of the separation of powers doctrine and therefore unconstitutional. And again, this was the opinion that informed the Supreme Court of Guam's opinion in the in re request of Gutierrez. So in that case, we're just having a bill that, gets a favorable or unfavorable. In this case, you actually have a recommendation, i.e. advice, to pass or to execute a contract which is all laid out in front of you. So maybe it's not as far as the previous opinion and what they were considering an in re request to Gutierrez, and it's not on the other side of Chafin, but it's in there. It's in that zone, which I think and we think is outside the zone of safety when it comes to a separation of powers violation. That's a long answer to, which could be shortened to, we do not believe that it addresses the question.
Thank you very much. Thank you, Mr. Chair. Thank you.
Thank you, Senator. We'll come back to you, Senator Rodriguez, on the second round. Do any of my other colleagues have any questions for this panel on this initial round? Senator Nelson, you're recognized.
Thank you, Mr. Chair, and I'd like to thank all of you for making time to come be here this morning. Attorney Espadon, I'll just kind of caveat. So just with your previous statement, with the AG understanding that it's on an unconstitutional premise, does that also make it inorganic?
Yes, we would say it's inorganic. And that's, you know, again, this position has to do with the form and how the legislature is trying to go about doing something. And we're saying that I don't think it satisfies the question of whether or not this would be organic or not. This would be organic. We believe it would not be. We also have underlying concerns of the legislation itself and the process by which, what's trying to be accomplished here. So.
And thank you for mentioning the process. Can you please, so the public understands, what is the proper process that should be done for cocoa recycling to perhaps appeal to this measure to seek some kind of fair claim or justice in this form?
Well, speaking of separation of powers here, I'm going to defer to the Deputy for the Litigation Division, Ken Orcutt, to answer that question.
Thank you. I think there's a real concern here that the executive branch should be the branch of government that's making a determination as to whether there is liability or not. I think there's two premises in this bill, or two conclusions that they make that I think are questionable. The first one is they say that the licensing agreement is valid. Well, the licensing agreement may not be valid. We've never looked into that question. But at the time that this lease or licensing
just a point of order, Mr. Orcutt. I believe the question was, what is the process by which a claim can be properly filed?
Mr. Chair, I respect the road the path that he's taking. He's bringing a lot of things into the light for the public. So if you would allow him to continue.
The concern is that we're not here to, we can have lawyers debating each other all day as to what their interpretations are. I think we need to be very specific as to the questions. So, Mr. Orcutt, if you can stay focused on the initial question.
There was two things, Mr. Chair, that he was bringing up. Please allow him to speak.
I believe your question, Senator Nelson, was what is the process for a claim? So I'll allow him to answer that question. If you have a follow-up question, you're more than welcome to proffer it. So, Mr. Orcutt, if you can stay focused on the initial question of the process for filing a claim, and if Senator Nelson has a follow-up question, she's more than welcome to proffer that.
Okay. Well, the process would be to file a government claim under the Government Claims Act. It would also possibly be filed litigation in the Superior Court of Guam for declaratory relief. But in this case, they've waited 17 years, and so they may be too late for some of these processes that they didn't take advantage of. Under the law, we have the concept of people, if they sit on their rights too long, they lose those rights. And here we have cocoa recycling that didn't do anything, as far as I can tell, for 17 years. So there's real concerns here about the process, or lack of process, of having this legislature take up this problem when they failed to go into the court system or the executive branch to seek relief there.
Is the legislative body somehow bound to fulfill this requirement because the process did not, perhaps the statutes of limitations have exceeded the necessary timelines, or?
The legislature could have a role here, but the problem that I see is that you've only heard half the story. I mean, Mr. Jarecki is a very effective advocate for his client, but you really haven't heard from our office because our office has never made an evaluation of this claim because there was no government claim submitted. So we really don't know the facts and circumstances. And as I was mentioning earlier, I think there's several premises that this bill has in it such as whether there's a valid licensing agreement and whether there's liability at all, that may not be true. I mean, Mr. Recchi could be right, but he could also be wrong. And the fact is, the matter is, as we sit here today with the AG's office, we don't know the answer to that question, and I frankly don't think the legislature does either.
Thank you very much, sir. Thank you, Mr. Chair. I still have some more questions. Mr. Harecki, good morning. You mentioned earlier in 2001, you have the licensing agreement for 25 metric tons, but it's not, what you are claiming is for work performed in 2003 and after. Is that correct?
No, the license agreement was 2001 July.
Okay.
It was for work prior that had already been done.
Before 2001?
Yes.
Okay, and so you're making the claim for the years 2003 after?
No, actually, I mean, we used that to point out that the total amount of work done was 50,000 tons, but the actual claim was already found by the CLTC to be the liability. They're the ones that determined that 25,000 tons had already been removed as of 2001, and that the value was 7.5 million.
How did they make that determination? Did they have someone, is there any documentation to substantiate that?
We did try to look into that. Yeah, the calculation is actually in the license agreement itself.
But the proof of the work being done?
From what we understand, and I believe it's also in the mayor's resolution, they apparently met with the company at the time that was doing the removal work on Guam after Typhoon Paka, that's DRC. So we understand that the commission had met with DRC. They're a big off-island company that does waste removal and help Guam after Typhoon Paka. That was who the CLTC consulted with. That was who the CLTC consulted with and determined their figures from that. But it was the CLTC that came up with those figures, not COCU. And they were presented to COCU as the reasonable amount of tonnage and the value that COCU had removed.
Mr. Harecki, I believe Senator Nelson's question was there any form of validation on that amount that was certified by the CLTC? Was there a validation, a receipt, or some kind of documentation, or was it just...
Other than the license agreement itself, no. I mean, it is right on the license agreement.
Okay. And the reason why, thank you, Mr. Chair, and the reason why I was asking is because we have the invoices here, and just the invoices that were given to us, and it adds up to what you stated earlier about 19,641 metric tons.
Yes.
And so this is valid documentation that work was performed. It's proof that work was performed because it involves shipments to Korea, shipments to Taiwan, and shipments to China for the waste. And so I just want to make it clear because we're under the presumption, or that there's 50,000 metric tons moved, but there's no, other than a license agreement, there's no concrete documentation to follow the amount that was removed other than these invoices that we have for 19,641 metric tons. And so that was just why I'm asking if there's anything similar to this or of the like that validates and proves other than a licensing agreement that is written up. I mean, usually all these things come with additional documentation. I do have another question. For Mr. Leon Guerrero from EPA, the rules and regulations for the Recycling Revolving Fund. I want to applaud the work that you have done as the EPA director and moving forward with the RRF rules and regulations. I know it has not been an easy road for you and your staff. But I want to also acknowledge the recycling initiatives that you look to implement with the Recycling Revolving Fund. First, I'd like you to share where the Recycling Revolving Fund comes from. Where does that money come from?
So the funding for that comes in, I believe it's a certain percentage from all registration of vehicles on Guam.
So when I go and register my vehicle, I pay a fee. How much is that fee?
I couldn't tell you exactly
It
right
varies,
now.
right? It
Yes.
varies depending on the make and model of the car and the year. Oh, Speaker Talahi said it's $25, so
Okay.
I'll take her word for it.
Yes. Yes.
And so this is the people of Guam's money. This is $25 that is supposed to go to Recycling Revolving Fund, which now you have finally moved forward with the rules and regulations. And I want to just share a little bit with you about that you probably already know some of the initiatives that you look to spend this money on or utilize it for the community. Again, we look to the Mayor's Council of Guam for the island-wide environmental cleanup. Then we go into the Recycling Industry Economic Stimulus Program, Guam Beverage Container Recycling is where we can finally find a way to allow a fair redemption of our aluminum cans or perhaps our plastic bottles like other states do. You can collect them and you can receive like some kind of rebate, perhaps like 5 cents per bottle on the return. Integrated Solid Waste Management Plan, Green Waste Plan, Disaster Debris Management, and that's usually in the cases of typhoons where we are always having a difficult time finding sites to put our waste at, our green waste and various other wastes, to store the Zero Waste Program, and to subsidize the recycling tipping fees for low-income household. And many times illegal dumping is done by people who do not or cannot afford to pay the fees for their trash to get picked up. And I see it all the time down Marble Cave Road because I drive down there every day. People just go and they dump their trash down there because they can't afford to pay GSWA fees for their trash to get picked up. I want to talk a little bit about your transition sites. And I know that's going, and this is a partnership that you work with US EPA, and also the plans for a building for EPA, because right now you are staying in a rundown building, you and all of Guam EPA. When there's rain, you have sewage coming up and you can smell the sewage with inside your building. And so I want to discuss a little bit about that. How do you work with US EPA to get their support and perhaps additional funding to build your transition sites? What is the impact? And then also for a government building that is appropriate and a standard that all employees should live under or should work under. Can you please just, thank you.
Thank you, Senator. I think the transition sites you're talking about, the transition sites that we're mentioning here as far as the disaster debris management. Okay, so knowing that every time that we have a major emergency, typhoon, heaven forbid, an earthquake or anything, solid waste is developed, for lack of a better word. And so FEMA, in its multiple responses to Guam, has mandated that Guam come up with these permanent transition sites that have infrastructure built into them and a security measure around them, whether it be a fence or security guards, so that all the transition sites can be clean and operated in an efficient manner, that it doesn't affect any other and bring about any other environmental issues. So that was one of the things. But before I go on, I wanted to say this initially. Draft rules and regs and the amendments you had, Guam EPA staff has worked hard and diligently to get to this. We actually have our public hearing tomorrow. I'm very proud of the work that we put together to develop the draft, because it's, by the statutes, we don't get the money besides what's in the statutes. And so, in effect, we're trying to get Guam to a better place. And I think these measures allow us to do that. And so that's why I'm very proud of these draft rules and regs. Of course, I'm open and the staff is open to hear any additional comments, and I want to use this, even though I may be breaking the rules, and I'm sorry, but we are having our public hearing on draft rules and regs tomorrow, and people should come and listen. Now going back to the transition sites, we saw that this is also a potential funding avenue to use this because the transition sites not only green waste, but it's white goods, metallic debris, et cetera, that we could utilize this and solve a very pronounced problem that Guam has when we have emergencies, which is required by, or is being required by FEMA to happen. So we see this as something that's good that can occur for Guam if these rules and regs get promulgated and we get to implement it at some point. And that's for the transition sites. As far as federal funding for our permanent home that Guam EPA will hold, I'm glad you've heard about this. It's been a push I've been trying to do for the last year. Just last week, we had the regional administrator of Region 9 here. He committed to Guam EPA and its staff that he would allow for some of the federal funding that we receive, as well as look into trying to get additional funding for us to build our home. And so that's where we're at as far as the federal funding goes.
Could some of this money be realized in that program that you just mentioned with your Region 9 US EPA representative coming down? Is it paramount that you have that kind of funding locally to support the Region 9 I guess recommendation or his efforts?
That's for Guam EPA's permanent home?
Yes.
So currently we are paying about $8,000 in rental fees, and that basically can be equivalent if we were to get a loan or do some process, whether through the legislature or just even doing the private contracting. That should be sufficient, so it shouldn't, you know, currently if we did it now or we move forward on it soon, we should be okay with that amount spent per month, yes. Which we're already doing as we speak.
And is there a way that, you mentioned transition sites, right? And for me, it's kind of like an important issue because just our last typhoon where the National Guard was mobilized, we had soldiers pulling security at dump sites. And that is unacceptable. You don't place a soldier in security at dump sites, but that was part of what the mission was called to do because the government did not have valid transition sites. And so, you know, march on. But does the transition sites require land, or does EPA have land in their books, or what land would you use to occupy these transition sites?
So, you know, we basically identified government property that is open and can be utilized at this point. If we were to make these permanent transition sites that we're proposing, we would have to work with land management, maybe with this body, to then identify and then permanentize that these are going to be the future land transition sites. Currently, we just use available property that can house that operation. Again, with our draft rules and regs, we're looking to permanentize these sites, both required by FEMA, but also just so that staff at Guam EPA, Homeland Security, land management, other powers that be don't always have to meet and see if these sites are available, if we can utilize them.
Is it government land?
Yes, sir. Yes, ma'am. I'm sorry.
And does EPA need to pay a rent for these transition sites if they occupy these government lands?
At this point, we do not pay any fee to utilize them, but again, we have to identify where they're at every emergency or even prior, just an emergency preparation. If there's a storm that may be hitting, we're called, staff are called in, and then we have to make a determination where a site is until these are permanentized as we're recommending in our draft rules and regs.
Has there been any thought or discussion that perhaps because of this has come into the light of this bill, has there been any thought about instead of using a different government agency to, I don't know what to say other than to pay this business, instead of using that, why don't we go to Chamorro Land Trust, use Chamorro Land Trust land, and pay rent to Chamorro Land Trust? Has there been any thought in that process of how do we right this wrong and allow the agency that is accountable to actually pay back instead of removing money out of the RRF so there can be capital improvement projects within EPA, and then also paying back what CLTC committed to?
I understand your question, Senator. I made the statement earlier. Decisions like that are not mine to be made.
Yes, I understand,
Yeah.
but has there been any thought to it within your staff or in your team?
As far
Different
as
avenues for growth of EPA, but also if there is a valid claim that this claim can be paid through its own agency, has there been any avenues looked into it further?
I mean, so a lot of the things that have been transpired and discussed is this valid claim? And I think that was asked to the Attorney General's office, which we understood to be that it wasn't, but then we were told that it is okay. But here, upon hearing Attorney Espaldon's discussion, that puts us back to, well, my Guam EPA's decision at this point is null and void until the AG determines this is allowable to go. And as a line agency for the government, that's what I'm mandated to follow. Now, if the body chooses to make a decision.
Thank you, Mr. Leon.
Thank you.
I appreciate it.
Yes,
Thank you.
Senator Nelson, that concludes your initial questions on round one. Any other senators? Senator Torres, you are recognized.
Thank you, Mr. Chairman. This is clearly a very, very difficult and complicated situation that we're placed with. In looking at it, it's incredible that we are dealing with a 2001 license agreement that established an ongoing contractual obligation to pay for services that were rendered on behalf of CLTC. What I wanted to just clarify is, Mr. Borja, would you say that it is accurate that this license agreement that was signed in 2001 was done so without any regard to a funding source to compensate for the services?
While I wasn't available in 2001 for this, the Chamorro Land Trust's obligation to this license agreement was to allow for a compensation based on a rental rebate, which comes out for so much per year, whatever the rent was times the length of the term of the agreement. That was its obligation, because that's what was intended for the cleanup to occur. But as I mentioned earlier, what resulted was the reality of other typhoons causing more debris to be laid upon, and this used as a disposal site for processing. So that's where the problem rests, is that it was originally intended to just clean an area up that was already soiled, and other events occurred that overtook what had happened.
Because what I believe this bill is attempting to do is to now amend the contract to allow for a dedicated funding source going forward, including an offset of rent.
Well, the offset of rent was already in the original license agreement. What this bill is intending to do is to amend the license agreement to allow, yes, as you said, an alternate funding source to pay for the other removal of debris that's above and beyond what the original license agreement with CLTC was intended for.
So then that clarifies something, because in the public hearing I had asked of Mr. Hurecki directly whether this situation is in fact a breach of contract or subject to a government claim. And the answer that I received, my recollection, was that there was never a dispute as to what was owned. So there was never really a need for a claim, because there was an agreement that just continued on for years and years through the different directors that took over the CLTC. But I think, though, that it's a little bit different here because we're not now looking at an original arrangement, but we're looking at compensation for what was not in an original agreement or situation, nor was it ever provided for going back. So we're trying to affect something retroactively through policy, which I question, and I continue to question whether it's the role of the legislature, although we could do anything we want today. We could declare ourselves something that we're not, just because we can. We can write ridiculous statutes and pass ridiculous laws that end up getting challenged and overturned in the court system. But notwithstanding that, we do want to do things right. And I cannot fail to acknowledge the absolute contribution that cocoa recycling has made to the community in terms of its removal of up to 50,000 tons of metric debris and old tires on CLTC land. But that said, though, the fact that there was an action done and an understanding made without any real contractual, there was nothing in contract or in writing that stipulated what was expected of cocoa and what was the promised compensation by the CLTC. Because Mr. Borja is talking about other than what was originally contemplated in 2001. And that's what I still can't wrap my hand around with. I understand what we're trying to do here in terms of making a certain amendments, but you're creating a situation and a fact 17 years after the fact. And for the legislature, as I'm trying to piece everything together, the more that I hear and the more that I try to understand what we're trying to do, it makes it that much more incredible. And I question whether, in fact, this really is a situation that is more of a settlement, a claim action that would then result in a process, administrative or judicial, and then a remedy through a settlement agreement or a judgment. I'm just, as a policymaker, looking at what's presented, I don't think that I don't think that we can do justice either to cocoa or to CLTC or to the EPA in what we're doing in this particular bill format of 350. I believe that there's also another party to this that we're not talking about, and it is the party that we've, as a body, the majority of us have been trying to protect in this term, and that is the body that's going to realize the effects of applying current or future revenues to past obligations. It's the indebtedness factor that I think is causing me to have some pause about the bill in its present format and the remedy to this very unfortunate situation that cocoa recycling finds itself in right now. And I acknowledge and I accept that cocoa recycling has provided a huge service to the island of Guam, a great benefit to the island of Guam. But the method by which we're trying to now make it right by cocoa through this legislation doesn't take into account all the factors. Have we arrived at the best settlement, at the just remedy that doesn't have an adverse effect to the community? And the adverse effect that I'm talking about is creating another obligation for a prior year debt using future funds. And that's where I have a little bit of pause. And I think in talking to the Attorney General, in listening to the Attorney General's office, it is those unknowns that I think have to be satisfied. Is there in fact a liability? Is the lease in fact valid? Is the claim in fact a valid and true claim? And is the method of payment going to be a realistic and sustainable method of payment going down the road? Is it a 20-year obligation, 10-year obligation? 10-year obligation. So I started out asking questions, and I apologize for more or less expressing my point. I don't think that there are really any answers or any comments to my point of view, or I would welcome you if you think that there is.
Senator Torres, you yield to the panel for anyone making a comment to your
Yes, please,
discussion.
because I do believe that in looking at this bill, anyone who is looking at this bill is probably as, not confused, but is picking up on certain things that are not so clear and not so convincing. And I yield to everybody to help us wrap our hands around this, because in the end, we're talking about a $7.5 or $5.9 million debt that is going to be paid by EPA funds that would otherwise benefit the community going forward. So please, yes, if you can clarify any of the points I brought up.
Thank you, Senator Torres. So her question is, does this action create a new liability on top of the existing liability that's already been established and that nobody is disputing? Is that your question?
That's one question. And the other question is it proper for this body to ascertain and arrive at what, not only the liability and the obligation and the validity of the contractual agreement, but is that within our purview, or is that really a function of another either administrative process or a judicial review process? Because it is a contractual issue, I believe.
Okay, so just to make sure the questions are going to be answered in uniform fashion, I'm going to paraphrase, and correct me if I'm wrong. Your question is this a new liability on top of an existing liability that isn't a new liability that may be disputable on top of an existing liability that isn't disputed? And the second question is there an administrative process to remedy this that hasn't been exhausted yet, or is this legislature the only possible venue at this juncture to remedy this issue? That's satisfactory, Senator Torres? Anyone of the panel wish to address these two questions? I'll take it. Anybody else wish to address these questions? No. So, Mr. Horecki, you're the only one that's offered to address these questions. You're recognized.
Thank you, Senator Torres, for those questions. I think we start out looking at the fact that this is a 17-year-old obligation, but it's undisputed that the entire territory of Guam benefited from the work that Koku Recycling did. There seems to be little dispute that it removed at least 25,000 tons of waste for the island, and that everyone benefited from that. In the license agreement, as I indicated, it expressly sets forth that it was determined and agreed back in 2001. This is the language of the license agreement, that in excess of 25,000 metric tons had been removed from lot 10-122-15. So that the work was done, I think, has been repeatedly established throughout this proceeding, and that the people of Guam, the territory, benefited from the work that was done. Now, as to the liability, the license agreement itself does recognize that the value of that service performed was $7.5 million. So I think there is something in the license agreement itself that serves as a basis for establishing that liability. I don't view it as a new liability. We also recall in the public hearing on this matter on Bill 98, which was the precursor, that the chairman of the CLTC had admitted that liability, basically that this compensation was owed for the value of the services that was performed by Koku. So I believe that the liability is not really a new liability. The only thing that is changing here is finding a vehicle or a means to satisfy that admitted liability, and that's the revolving recycling fund.
May I interrupt you just for clarification? So, because of the amount of waste that was removed, it resulted in a value of $7.9 million worth of service by COCO. And as Mr. Borja indicated, the arrangement for the license agreement was for the fees to, or the repayment to COCO to be made by an offset against the lease payments. So what we're really talking about is over the course of time for COCO to exhaust $7.9 million worth of lease is really an impractical arrangement. So we're adding now a monetary payback factor of a portion of that. That's what we're doing with this, correct?
Well, in part, but it's based on the value stated in the license agreement.
Yes.
And I'd also point out in 2012, GITA did a study on this license agreement. They believed that there was a liability there, and they also indicated that if you only applied these amounts as rental credit, it would take COCO approximately 94 years to be compensated for the work that it did. So I think the liability is an existing liability. The means for payment through the recycling fund is exactly what the recycling fund is established for. It says right in the section of the law. I believe this question had been asked earlier. The main provision of the recycling law does provide that there can be compensation from that fund for removal of waste, solid waste, green waste. I think the director of EPA also attested to that. So that fund has been used previously to
Mr.
address
Hurecki, I don't
this
think
kind of liability.
Senator Torres was disputing that the recycling and revolving fund could be used as a funding
Yes.
source. I think her question specifically was, this liability is tied to the offset in leases that COCO Recycling was supposed to be liable for. They no longer have to pay that as a result of this liability, but the inconvenience is that that agreement is going to result in a 94-year duration for them to pay off this liability, but they still have that remedy. They're still able to pay off the liability. It's just going to take 94 years, as opposed to the faster method of taking cash from the recycling and revolving fund to pay that. Am I accurate so far, Senator Torres?
And the reason that I'm asking these questions is because everybody is trying to figure out or come to terms with the fact that we now owe you $5.9 million. And if you go back to the original question, it's like, how could we possibly owe you $5.9 million, and why was nobody paying? Now, the answer to that is there was never an intention, per Mr. Borja's statement, that it was going to be a cash for service. It was an offset arrangement. But, you know, and so that's what I think, you know, we're trying to clarify is why are we talking about now hard cash? It was at one point just an offset arrangement, but of course the services, because of storms and the like, went far beyond what was originally contemplated. So now we're trying to make whole what we, I don't know if encouraged or allowed you or asked COCO to perform on behalf of CLTC. But I'm sorry, go ahead.
So that satisfies your initial question, Senator Torres?
It does,
And
yes.
so onto your second question, Mr. Hurecki, you're afforded the floor to answer. If you believe there may be an administrative remedy other than this legislation to be able to resolve this outstanding liability.
I truly believe that it's the legislature that can give the most appropriate remedy. You know, part of what we're seeking is also the remediation of the lot for which the license was given. That's the lot next to a Department of Revenue and Taxation. That lot needs to be remediated too. So that is a part of this agreement and a benefit that can only be recognized if the legislature provides a remedy. And that's why part of the fund was allocated, over $300,000, to apply to remediation. But the problem is, without the amendments to the license agreement, as well as compensation for work done, COCU can't do the remediation. So that part of the remedy is certainly something only the legislature could do. Again, going as to whether there could be other administrative remedies, we truly felt that there was not a need to go through a government claims route because, as I mentioned, every director in the CLTC, going back for years, had agreed to the remedies. I know earlier, I'm deviating a little bit, but the Attorney General had indicated that they felt that the contract provisions were still somehow violated the Organic Act. But those don't require, by the way, that the CLTC accept the remedies proposed in the law. But those contract provisions have been discussed with all of the directors and basically agreed to, at least orally. We never had a signed amendment, but both prior directors and the existing directors had agreed to those provisions. So the legislature, by recommending those provisions, that is another remedy that would at least give the option to the CLTC. The reason we came here to the legislature was that the CLTC said they couldn't adopt those provisions without a recommendation from the legislature. So I think the legislature is the appropriate body to resolve this almost 20-year issue that has been pending. Any other remedy or approach is not going to be effective. It will take probably many more years, and we never know if there will be a remedy. But unless the legislature takes some action now, this is just going to be another unsolved past owed debt and a situation that never gets resolved.
Just to clarify, Mr. Horeki, the existing liability of COCU to the Chamorro Land Trust, is that continuously being offset by this balance? Or is COCU paying the Chamorro Land Trust?
At present, the rent is being offset.
The rent is being offset by the liability.
Yes.
So the liability is currently being retired just at a very slow rate.
Correct.
Okay. Mr. Borja, there's been several references to the director making certain commitments. Did you want to weigh in and comment as to the accuracy of these statements by Mr. Horeki, or would you prefer to defer at this time?
No, we did have discussions, and there were discussions, I think, that were noted in different minutes to older meetings discussing this in years past. So it has been a discussion within the CLTC, but it was also recognized that the CLTC didn't have authorities to go beyond making amendments to something that, especially for compensation, that they didn't have any authorization for. And likewise, you know, a lot of these license agreements that were created by the CLTC in these early years were, you know, things that we probably wouldn't be entering into today, and we would call them lease agreements, and there were no commercial rules and regs in place at the time. So times have changed, and so those are the kinds of things that we would definitely look at in today's world, would be trying to do any kind of commercial agreements through rules and regulations, unless the legislature authorizes the Chamorro Land Trust through legislation and public law, like was recently done for the Guam Raceway. So those are the kinds of exceptions, and that's what we were looking at here as well. The compensation part of it, you know, we all recognized the work was done. We just, you know, we looked and discussed various other ways that payments could be made. I think the suggestion was to allow the cocoa recycling to have rent credits up to, you know, almost $5-6 million, and they could sell it, and we were adamantly against that, just because if you sold it to all our existing commercial agreements, we wouldn't have income for a number of years, and that even if they sold it on 50 cents on the dollar.
But just to clarify, though, Mr. Borja, that remedy is available? Is that an administrative remedy that's available for this liability? Because that's the question from Senator Torres, are there any other administrative remedies?
To have rent credit for the balance of all these funds? No, it wasn't something the CLTC board wanted at all. They didn't recommend that.
Senator Torres, are you satisfied?
I am, and thank you very much, because I think all of you put it into perspective what we're really dealing with. You know, the issue of cash and payments going forward of cash is what's, I think, alarming. But I can understand what we're really doing is you're putting a value, and rather than dragging out an offset, which is an unrealistic offset for more services than were probably contemplated in the beginning when the license was issued, we're dealing with something it's quite unusual to do. But I can see how this was proposed as a remedy to a long-standing issue. It makes sense to me. I don't necessarily agree that it's the best way going forward, because we are now looking at carving out about 25% of what is supposed to be monies going forward in EPA's projects and mandates that's now going to be used to cure prior debt. So that's the part that I think we have to be aware of when we make a decision to vote on such a measure or not. But thank you very much for, you've certainly clarified, Mr. Borja, you've clarified what this license agreement was initially that perhaps was missing from the legislative intent, or it wasn't captured. But thank you.
Are you satisfied with your initial round of questioning, Senator Torres? Colleagues, we're approaching half past the lunch hour. Would you like to plow through this initial round and recess after we've concluded? I'll assume that's a yes. Any other senators have any other questions for this panel for this initial round? Senator Terlai, Acting Speaker. I was just asking if anybody wanted to recess and return after lunch, or if you'd like to question prior to the lunch hour.
I'd like to make a motion to recess and return after the lunch hour.
We have a motion on the floor to recess for a lunch hour. We'll return at, it's already 12:30, maybe 2 o'clock. Is there any objections? No objections, so ordered.